We are done with the first right. The second right is right to claim damages. Now, what do you mean by damages? Damages means right to claim compensation for loss suffered. You have suffered some loss, and when you claim compensation for it, this is called as damages. So damages means claiming compensation for the loss suffered, and right to damages means right to claim compensation for the loss suffered. Now, because of my breaching of the contract, you might have suffered some losses. Let's say I was to supply 500 bags of rice to you at a price of 10 rupees per bag. Okay, now I cancel the contract. When I was supposed to deliver the bags of rice, I tell you, boss, I cannot deliver the rice to you. I do not have any rice with me to deliver it to you. But you have contracted with someone else that you will supply rice to him. So now you want 500 bags of rice. So what you do is you go and purchase the rice from the market. Now in the market, now the price of rice has gone up by 2 rupees. So now you will get rice for 12 rupees per bag. So for 500 bags, you have suffered a loss of rupees 2 per bag. So in all, you have incurred a loss of 1000 rupees. This 1000 rupees is your loss, and you have the right to claim the compensation for this loss from me. And this compensation for loss is called as damages. The loss that you incur, the loss that you suffer, the compensation for such loss is called as damages. So you get the right to claim damages from me. Now, what is liquidating damages? Liquidating damages means the damages are ascertained in the contract itself. When we are making the contract, in the contract itself, we calculate. What do we calculate? We calculate the situation wherein the contract is breached. We assume that the contract is breached. And if the contract is breached, what will be the expected or the estimated loss to the either party? If this loss, the amount of loss is estimated in the contract itself. Because let's say the contract was to be performed after a month. The contract was to be performed after 15 days or 10 days. So if after 10 days the contract is not performed, or after a month the contract is not performed, whenever it was due for performance, it is not performed, what is the likely loss to the either party? And when this likely, this estimated, this expected loss is put into the contract itself, it is ascertained in the contract itself, it is called as liquidating damages. So the party now becomes liable for liquidated damages. The next is ordinary damages. Ordinary damages means the actual loss which the aggrieved party has incurred in the normal ordinary course of business. The example that I gave you was 500 bags of rice I was to supply to you at rupees 10 per bag. Now you will have to purchase it from the market at 12 rupees per bag. So 2 rupees is the actual loss per bag that you are suffering, and 1000 rupees in totality is the actual loss that you are suffering. This loss will be called as ordinary damages because this is the actual loss that you are suffering. This is not the estimated loss. This is not the expected loss. So this is the actual loss. So this is the difference between the two, liquidated damages and ordinary damages. Liquidated damages are expected in the contract. When the contract is made, you estimate that if the contract is breached, what will be the expected loss. And ordinary damages, it is the loss that you actually bear, that you actually incur in the situation where the contract is breached. So, which of the two do you think the court will go ahead with? The court will award to the aggrieved party. Which of the two? Liquidating damages is decided by the both parties. It is put into the contract by the both parties. It is ascertained, estimated and put into the contract. However, ordinary damages is the actual damage that the aggrieved party has incurred because of the breach of contract. This was agreed. This is not agreed, but it is actually incurred. So which of the two do you think the court will award to the aggrieved party? The court will award ordinary damages to the aggrieved party. Because in liquidated damages, it is the estimated loss. Now, court cannot go ahead, court cannot award the estimated loss. Court will always see what is the actual loss that the party has suffered. And according to the actual loss, it will award the damages to him. Liquidated damages may be anything. Let's say we contracted at 10 per bag and we estimate that if the contract is not performed, possibly the loss might be, the price per bag might reach 15 rupees. So in that case, 5 rupees per bag for 500 bags comes to around 2,500 rupees. So we put in the contract that liquidated damages would be 2,500 rupees. But actually, what happened was the contract was breached and you could get the rice from the market at 11 rupees per bag. So your loss was only 500 rupees for 500 bags, 1 rupee per bag. So in this case, the court will award you damages of 500 rupees because that is the actual loss that you have suffered. You may estimate anything. You may underestimate also, you may overestimate also. The court is not much concerned about liquidated damages. It is more concerned about ordinary damages. Okay. The next type of damages is special damages. Special damages occur in special circumstances only. Like ordinary damages happen in the ordinary course of business, special damages occur in special situations only. They are not, it is not the loss which happens in the ordinary course. It occurs in special situations. Like, let's say, I agree to supply 500 bags of rice to you, but because there was a riot in the city, I couldn't supply the rice to you. Now this is not an ordinary transaction. This is not an ordinary event. This is a special event. So in this case, the court will investigate as to was this special event directly responsible for the breach of contract. Could I have done anything else? Could I have taken some other route and delivered the rice to you? So the court becomes a bit more investigative, a bit more suspicious, and it tries to do the fact finding. If the cause of the breach of contract is directly related to breach, then the court might award special damages. Otherwise, getting the special damages is not the exclusive right of the aggrieved party. It might only get special damages in some special situations, in some special circumstances. Like ordinary damages is the right of the aggrieved party. Whatever loss it has suffered, it will get. But special damages is suffered in special cases. So it might not get special damages in all the cases. Now, one example that I would like to share with you is, you come to me for construction of your house. I say I'll take 3 months to construct your house. Okay. And because now you know the timeline, the deadline of the house being constructed, you give your house, which would be constructed after 3 months, for rent starting when the house is completed, that is 3 months from today. So now your rent will start from after the third month. But what I do is I take time in completing the contract. I complete it by the fourth month. So by the end of fourth month, you have already lost 1 month's rent. But I give the possession of the house to you, and you allow the tenant to move into your house. The tenant moves in, and on the second day, the ceiling falls. Now, my work was shabby, and because of that, the ceiling falls. Now, after handing over the possession to the tenant, you go away for some vacation. You visit some hill station or something of that sort. So you are not available there. So your tenant, what does he do? He does the repairing work of the house. Now this repairing work takes around 15-20 days. Let's say a month for our convenience. And for that 1 month, he had to move into some other house and pay rent there. At the same time, he also paid for the repairing work that he had done in your house. Now, your tenant recovers. When you are back, your tenant recovers the cost of repairing work that he had done for you. Now, in this case, what will happen is you get the right to recover ordinary damages from me as well as special damages from me. The ordinary damages are the cost of repairing work that you always can recover from me, because that was your loss. Your tenant bore that cost to you, cost on your behalf, and you repaid it. So now it is your loss. You can always recover it from me. That is the ordinary damage. At the same time, there is special damage that has that you have incurred. That is 2 months rent. 1 month I delayed the work. The second month went in repairing the house. So 2 months rent also you can recover from me. This would be a special damage. You're getting my point? In this case, we have seen both the types of damage, ordinary and special. Ordinary damages is the cost of repair work that you have actually paid, and special damages the loss of rent that you have incurred. You did not get rent for 2 months, so now that you can recover from me. That will be a kind of special damage. But please remember, special damages are not awarded in all situations. It is not the exclusive right of the aggrieved party. The aggrieved party gets it only in some special situations wherein the cause of the breach of contract is directly related. It is directly related to the breach of contract. Wherein the cause is remotely related, it is not directly related, but it is indirectly related, it is remotely related, then you might not get special damages. You'll only get ordinary damages. The next type of damages is vindictive or exemplary damages. Now, what do you mean by these words vindictive or exemplary? Vindictive means punitive, intending to punish, intending to teach a lesson. And exemplary means setting an example. I'll write it for you. Vindictive means punitive, involving some punishment. Exemplary means setting an example. So this is the kind of damages that sets example, that gives some punishment to the party who breaches the contract. Now, in all these cases 1, 2, and 3, the spirit behind the damages is to compensate the aggrieved party for the losses incurred. The spirit here is, in all these liquidated, ordinary, and special damages, the spirit is to compensate the aggrieved party. But in this case, the spirit of law is to punish the party who breaches the contract. It is punitive in nature. It is exemplary in nature. It wants to set an example so that other people do not break the contract. They do not breach the contract. But this kind of damages is available only in two cases, only in two conditions. The two conditions are, first, when the contract to marriage is breached, and the second case is when the check is dishonored. Now, when I say the contract to marriage, the first question that should arise in your mind is, a contract to marry is not a business contract. So, when a contract to marry is not a business contract, where is the question of incurring a loss? There's no question of incurring a loss, right? But this contract has been inserted to set an example so that other people do not make loose and vaguely meant contract. A contracts with B that he'll marry her after a month, and after a month he tells her that I was just kidding, or I wasn't serious, or possibly I have somebody else in my life. So people should not make contracts to marry where they do not actually mean them. People should make contracts of marriage where they are very much serious, where they actually mean them, where they are actually committed. Because marriage is a very important thing. It's a big occasion in our life. And breaking of marriage, that is breaching of contract of marriage, leads to a lot of mental distress, leads to a lot of mental agony. It might also lead to financial loss as well, because you do all the preparations for your marriage. You make the arrangements for the lawns or the halls, you make the arrangement for food, you make the arrangement for decoration, and suddenly the other party comes and tells you that he's not serious, he will not marry. So, one, it might cause financial loss, but even if it doesn't cause any financial loss, it does cause a lot of agony. It does cause a lot of distress. So the court is of the opinion, if a person who is not serious enters into a contract of marriage, should get punishment, and an example should be set so that other people do not follow his case. So now, depending on the mental distress, the mental stress, the mental agony that the person has undergone whose marriage has been broken, the court decides the compensation on the level of stress that the person had undergone, the level of pain that he has experienced. Because there might be people who might be okay when their marriage is broken, but there might be other set of people who might be in a lot of pain if the marriage is broken. So, depending on the agony and the pain that they have undergone, the court might decide the amount of compensation. The second case is bouncing of a check, that is dishonoring of a check. If a check is dishonored, again, the court tries to follow the suit, saying people should not just write checks when they do not have balance in their accounts. They should only write checks when they have balance. Many times, what businessmen do is they write checks knowing that they do not have balance in their account, but they they write checks such that they do not face pressure from the other side. For some time, they'll be relieved. So they try to fool the other party by writing checks, by drawing checks. So court is of the opinion, law is of the opinion that you should draw checks, you should write checks only when there's sufficient balance in your account, when you actually intend to pay from those checks. If you do not intend to pay from those checks, or there is not sufficient balance in your account, then you should be punished. Then you should be made to pay damages. Now there's a rule defining this provision. The rule is, smaller the amount of check, bigger would be the compensation, or higher would be the compensation. So if a check of rupees 500 or 1000 is dishonored, the compensation on it would be bigger against a check of 5 lakhs getting dishonored. Because a check of 5 lakhs getting dishonored is understandable. Let's say he had only 4,50,000 in his account. But a check of 500 getting dishonored, a check of 1000 getting dishonored is not conceivable by court. The court says a businessman, if he cannot honor a check of 500, if he cannot honor a check of 1000, he should not ideally be drawing checks. He should not fool people. So, smaller the amount of checks, larger is the compensation, larger is the punishment. So, this is the rule. So, this is kind of damages which is set, which is allowed to the aggrieved party to set an example, to punish the party who is breaching the contract. Compensation to the aggrieved party is not the main motive here, which is in the first three cases. The next is nominal damages. Now, nominal damages is a case where no real damages occur to the aggrieved party. I was to supply 500 bags of rice to you. When I was on the due date, I come to you and tell you I cannot supply 500 bags of rice to you. So you get it from the market, and in the market also you get at the same rate. So now in this case, you are not incurring any loss. There is no real loss to you. So ideally, when there is no loss, you should not be claiming compensation from me. and court also appreciates this point. However, what court also says is, in such cases where the party expects that there'll not be any loss to the other party, it might breach the contract anytime. So this will lead to indiscipline amongst the businessmen. This will also lead to mistrust, indiscipline and mistrust amongst the businessmen, which is not what the law wants. The law wants smooth functioning of the industry. The law wants smooth functioning of the business. So what it does is, even though there is no loss which has occurred to the party, the court awards nominal damages. Now, nominal damages means damages of, let's say, 1 rupee, 50 rupees, 10 rupees, 100 rupees, but not more than that. Now, I know these damages are they are very petty, very small, and the party probably won't mind paying it. But the important thing is, for paying these damages, we have to come to the court. He'll have to go through all the legal procedures, and that would be cumbersome for him, and that would act like a punishment for him. So again, in this case, the essence, the rationale behind the damages is not to compensate the aggrieved party, but it is to set the example so that people do not breach contracts. The last kind of damages is deterioration caused by delay. Many a times there is delay in performing the contract. Let's say I was to supply oranges to you. We enter into a contract today that tomorrow I'll supply oranges to you. Let's say 50 dozens of oranges. But what I do is, tomorrow I did not supply. On the due date, I did not supply. I supplied it 2 days after the due date. And in the process, what had happened was, some of the oranges were rendered inconsumable, or the oranges went overripe. So what happened was, the quality of the oranges declined. The quality of the oranges deteriorated. The freshness in the oranges wasn't maintained. So you can say that the quality had deteriorated. Now, when you go out in the market to sell those oranges, you do not get the price that you wanted. Let's say you were to get 5 rupees for each orange. Now you are getting only 3 rupees each orange. So now you get the right to recover 2 rupees per orange from me as damages for deterioration caused because of delay. I had caused delay in the performance of contract, because of which the deterioration in quality was caused, and because of this deterioration you could not recover the price from the market, because now it has become of substandard quality. The quality is not maintained, it has deteriorated. So now you are incurring a loss, and that loss you can recover from me. So that would be called as damages caused because of deterioration, caused because of delay in performing the contract. This damage is caused because of deterioration, because of delay in the contract, is almost like the ordinary damages only. It's just that this pertains, this relates, this is more relevant in cases of perishable goods. In perishable goods, if there is delay in performance of contract, the quality of the goods goes down, the quality of the goods deteriorate. So probably because of that, you might incur a loss. And if you actually incur a loss, you can recover it by claiming compensation under this head, under the head deterioration caused because of delay. Otherwise, it's almost like ordinary damages.